Article 1, Section 8, Clause 1 also includes the spending power. It states that Congress shall have the power to pay the debts and provide for the common defense and general welfare of the United States. Like the taxing power, the language that confers the spending power seems limited only by the political process. But the court has wrestled with whether there are structural federalism limits on the purposes of federal spending. One test of such limits was in the context of a New Deal case, U.S. v. Butler. When we discussed Wickard v. Filburn in Unit 4, we mentioned that the statute at issue in Wickard, the Agricultural Adjustment Act of 1938, was the successor to the statute at issue in Butler, the Agricultural Adjustment Act of 1933. Remember that these statutes were designed to support farm prices by restricting supply of some commodities. The 1933 statute sought to incentivize farmers to reduce production of key commodities through contracts with the U.S. Secretary of Agriculture, which would provide benefit payments to the farmers for the reductions. Money for these benefit payments was obtained through a tax paid by processors of these commodities, for example, by a mill that processed wheat into flour. In the majority opinion, Justice Owen Roberts, no relation to today's Justice John Roberts, first addressed a basic question about the spending power. Is the Congress's power to tax and spend only incidental to other enumerated powers in Article 1, Section 8, or is the spending power a separate power not necessarily tied to the other enumerated powers? The former view historically had been advocated by James Madison and the latter by Alexander Hamilton as part of their ongoing debate about the nature of federalism under the 1789 Constitution. If the former view were correct, then federal spending would be constitutional only if the congressional scheme were justified by another enumerated power. If the latter view were correct, Congress could spend without any hook to another enumerated power. Justice Roberts determined that Hamilton's view was correct. The spending power is an independent power of Congress. Nevertheless, Justice Roberts concluded that there were inherent federalism limitations on the exercise of the spending power. Congress was free to condition spending within a state on requirements related to federal policy goals, but not if the extent or nature of these conditions denied the state's authority to regulate in areas of traditional state concern. According to Justice Roberts, the spending scheme at issue in Butler was not really a voluntary program because the power to confer or withhold unlimited benefits is the power to coerce or destroy. He drew a distinction between a statute stating the conditions upon which money shall be expended and one effective only upon assumption of a contractual obligation to submit to a regulation which otherwise could not be enforced. The majority therefore found the 1933 statute unconstitutional. Justice Stone wrote a dissent joined by Justices Brandeis and Cardozo, which highlighted the difficulty of this kind of line drawing. According to Justice Stone, it is a contradiction in terms to say there is power to spend for the national welfare while rejecting any power to impose conditions reasonably adapted to the attainment of the end, which alone would justify the expenditure. In other words, if Congress really is empowered to spend in support of the national policies, there's no way to draw a federalism line against conditions on receipt of expenditures. The difficulty of such line drawing arose the next year in the Social Security cases decided in 1937. Today, most of us take the Social Security scheme for granted, even if we wonder whether it will remain financially viable by the time we need to access it. Prior to the New Deal era, there was no national economic safety net for disabled workers, temporarily unemployed working-age persons, or older retired persons. Starting in the early 1930s, a few states began to experiment with unemployment compensation insurance statutes, but the rate of state adoption of such laws remained very slow. The federal Social Security system provides both disability coverage and retirement benefits overseen by the federal government. Revenue for these benefits is raised through a payroll tax on employers, which is paid into the general treasury. If a state does adopt its own benefit system, the federal statute provides for a federal tax credit to employers for most amounts paid into the state system. In Charles Stewart Machine Co. v. Davis and Helvering v. Davis, this scheme was challenged as a misuse of the spending power and a violation of the 10th Amendment. The court, in majority opinions authored by Justice Cardozo, held that this system did not unduly coerce the states. In Stewart, Justice Cardozo agreed that a line must be drawn somewhere, but stated that we do not fix the outermost line. Enough for present purposes that wherever the line may be, this statute is within it. And in Helvering, Justice Cardozo stated that in drawing the line between general and local welfare, that is, between areas of appropriately federal and state concern, the discretion belongs to Congress, unless the choice is clearly wrong, a display of arbitrary power. As with other federalism issues in the wake of the New Deal then, it seemed that there were essentially no limits on Congress's ability to attach conditions to federal spending. Yet the contours of the spending power became an issue again in the new federalism era of the Rehnquist Court, although Justice Rehnquist ultimately demonstrated deference to congressional judgments about spending. This is evidenced in South Dakota v. Dole, a 1987 case. The federal statute in that case was a response to the problem of drunk driving. Roads are a quintessentially local political problem. A politician who can't get potholes fixed isn't worth much. But building and maintaining roads is expensive, and roads are part of the national infrastructure, so roads are also a national issue. The federal government runs a variety of programs that provide aid to local road construction and maintenance. The National Minimum Drinking Age Act stated that 5% of federal highway funds would be withheld from any state that permits a drinking age below 21. South Dakota challenged this provision as an impermissible effort to control a matter traditionally within the state police power. The court ultimately rejected this challenge. Justice Rehnquist stated that Congress may attach conditions on the receipt of federal funds and announced a 4-part test for assessing the constitutionality of federal spending decisions. Under that test, 1, the spending must be in pursuit of general welfare, suggesting broad deference to Congress. 2, the spending conditions must be stated unambiguously so states can exercise knowing choice. 3, the spending conditions must be related to the federal interests in particular national projects or programs. And 4, the spending conditions must satisfy any other applicable constitutional provisions, meaning the conditions must not induce the states to do anything unconstitutional. In relation to the Drinking Age Act, Justice Rehnquist held that the first 3 parts of this test were clearly satisfied. As to the 4th part of the test, South Dakota argued that the federal policy conflicted with the 21st Amendment, which repealed prohibition. Justice Rehnquist rejected this argument, holding that limits on the drinking age are not another way of enacting prohibition. Justice O'Connor dissented because she disagreed with the 21st Amendment argument. Section 2 of the 21st Amendment states as follows: the transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the law thereof is hereby prohibited. Justice O'Connor argued that this provision evinced an intent to leave all regulation of alcohol entirely to the states, and that such regulation would include the drinking age. And now we come once again to the Obamacare case. Recall that Obamacare not only required individuals to obtain health insurance, but also affected other parts of the insurance safety net, including Medicaid. Medicaid is the program that provides government-sponsored health insurance to low-income persons. It is jointly funded by the federal government and the states. States can establish their own rates for Medicaid service providers within federal guidelines, and the federal government reimburses states for a percentage of state program expenditures, called the Federal Medical Assistance Percentage, or FMAP. Obamacare expanded the Medicaid program by requiring all states to provide Medicaid coverage for any adult with an income up to 133% of the federal poverty level. Here's a chart of the 2018 federal poverty level for the 48 contiguous states in Washington, D.C., which includes the 133% level and other percentage levels. Prior to Obamacare, some states did not provide Medicaid to persons at the 133% above poverty level. Obamacare provided that any state that failed to comply with the new requirement will not qualify for increased Medicaid funding and could lose all existing Medicaid funding. Justice Roberts flipped back with the conservatives in holding that this provision violated the spending clause, joined on this issue by Justices Breyer and Kagan from the liberal bloc. Notice that Justice Roberts did not apply the Dole test nor any other analytic test. Instead, citing Stewart-Machine, one of the Social Security cases, Justice Breyer said even if he could not fix a firm line for when a spending provision is unconstitutional, it is enough for today that wherever that line may be, this statute is surely beyond it. According to Justice Roberts, this provision was not merely an inducement, but was a gun to the head, because the consequences to states of losing all Medicaid funding would be financially catastrophic. Finally, Justice Roberts made a somewhat novel move concerning the severability of this provision. Instead of invalidating all of Obamacare's Medicaid expansion provisions, he held that the Secretary of Health and Human Services, the executive branch agency that oversees Medicaid at the federal level, could not withdraw existing Medicaid funds if a state failed to comply with the Medicaid expansion. This left other aspects of the Medicaid expansion, including possible limits on new funding to non-complying states, intact. Justice Scalia, joined by Justices Kennedy, Thomas, and Alito, agreed that Medicaid expansion spending provision violated the spending clause. It was, he said, echoing the famous line from The Godfather, an offer the states are not really free to refuse.
You spend time with your family?
Sure I do.
Good. Because a man who doesn't spend time with his family can never be a real man. Come here. You look terrible. I want you to eat. I want you to rest well, and a month from now, this Hollywood big shot's gonna give you what you want.
It's too late. They start shooting in a week.
I'm gonna make him an offer he can't refuse. Now, just go outside, enjoy yourself, and forget about all this nonsense. Listen, I want you to leave all to me.
All right.
Yeah?
In contrast to the majority, however, Justice Scalia argued that the entire Medicaid expansion should have been invalidated. This is an interesting and potentially significant difference from Justice Roberts. What do you think motivates this difference? Whose approach is better? Justice Ginsburg, joined by Justice Sotomayor, disagreed with the majority and dissented from the spending clause portion of Justice Roberts' opinion. She echoed a theme we have seen in other dissents in similar cases. Obamacare is an exercise of cooperative federalism that should be encouraged. Further, Justice Ginsburg noted, this was the first time since the New Deal era that the court had ever invalidated a spending provision under the spending clause and contradicted earlier precedents, including those New Deal era Social Security cases. As you can see then, the spending clause is another domain in which federalism principles and doctrine are in flux. We'll discuss all of this further when we meet in person. This is the end of the lectures for this unit.